Dear students, viewers and the subscribers, welcome to the IAS Mentor. This would be our lecture number 122 in the series Indian Polity. We are almost coming to the end of the long series which has happened for more than 4.5 months, and I'm sure that this series is going to be really beneficial to lakhs and lakhs of students preparing for UPSC examination and other competitive examination in the coming years. But for the maximum benefit, students who are starting to prepare their preparation, I would recommend them to go through the series in a chronological order. And by doing it in a chronological order, you will have a proper understanding, because each and every lecture is chained to the next lecture. So that is the reason I am recommending that to all of you. All right. So what is the topic that I'm going to discuss in this particular lecture? The topic that I'm going to discuss in this particular lecture is the constitutional amendments. Some important amendments have happened to the Constitution of India, and that is exactly what we are going to discuss in this particular lecture. So not each and every amendment. In the last class, I asked a question that how many amendments have happened to the Indian Constitution till this point of time. The number of amendments that has happened to the Constitution of India till this point of time is 106 constitutional amendments. But however, not all the 106 amendments are very significant. So UPSC does sometimes ask the significant amendments as a part of the examination. Usually the latest amendments and some significant amendments which has made major changes to the Constitution. Say for example, the 42nd Constitutional Amendment Act is considered to be the mini parliament. Sorry, the 42nd Constitutional Amendment Act is considered to be the mini constitution. It has amended so many provisions in the Constitution, it was considered to be the mini constitution. So apart from that, there are a lot of other significant amendments also, which we'll subsequently discuss as we'll proceed further. All right. So selectively, we'll try to look into the provisions of some of the amendments, and one such amendment is the first Constitutional Amendment Act. What is the major change that was inserted by the first Constitutional Amendment Act? In fact, it inserted Article 31A into the Constitution. Before that, there was no Article 31A. Article 31A provides protection to certain categories of laws, especially the laws which are aimed at bringing agrarian reforms. And those laws cannot be challenged on the grounds of violation of Article 14 and Article 19 in the fundamental rights. This is the provision of Article 31A. And the same first Constitutional Amendment Act has also brought in Article 31B, which provided for the 9th schedule in the Constitution. And regarding 9th schedule, I already discussed. So what is this 9th schedule? Briefly, the 9th schedule is a schedule in the Constitution where any law which is placed inside the 9th schedule initially was having a blanket immunity. Today there is no concept of blanket immunity, but still the laws which is placed inside the 9th schedule have certain level of immunity. And what is the immunity that they have? They can be challenged only on the grounds of violation of the basic structure, not on any of the other grounds. And then Article 19 was also inserted by the Article 19 was also amended by the first Constitutional Amendment Act. And what was the change that was brought to the Article 19 is more number of reasonable restrictions has been inserted. In fact, if you see Article 19 Clause 2, today there are 8 reasonable restrictions to the right of freedom of speech and expression, but not all these 8 restrictions were part of the original Constitution. Only there were few restrictions, and some of the restrictions that was brought in by Article 19 Clause 2, which includes by the first Constitutional Amendment Act on the grounds of public order, friendly relations with foreign state, incitement to an offence. Now these things were not part of the original Constitution. Subsequently, these reasonable restrictions were inserted. In fact, there was one question in previous year UPSC that which of the following amendments were related to the fundamental rights. In fact, the most appropriate among them was the first Constitutional Amendment Act, because you can see all these articles that was inserted by the first Constitutional Amendment Act, or all these changes that was brought in by the first Constitutional Amendment Act, they are more or less related to what is called as the fundamental rights. So this is how UPSC can indirectly also ask the question. So please come to the next amendment in the Constitution, the 7th Constitutional Amendment Act. The 7th Amendment is also significant because the 7th Amendment was largely based on the recommendation that is given by the first Reorganization Commission. And subsequently, the Reorganization Act 1956 was passed, And along with the Reorganization Act, to make changes in the Constitution to accommodate the reorganization, the 7th Constitutional Amendment Act was also passed. So what are the changes that was brought in by the 7th Constitutional Amendment Act? So in fact, the 7th Constitutional Amendment Act has abolished the classification of fourfold states. Before the 7th Constitutional Amendment Act, the states in India was basically classified into Part A, Part B, Part C and Part D states. Now that has been done away with by the 7th Constitutional Amendment Act, and it brought in a classification of states and union territories. So 14 states and 6 union territories were brought in. In fact, a new part was inserted into the Constitution related to union territories. Before the 7th Constitutional Amendment Act, there was no mention of the word union territories. So this change has been brought in by the 7th Constitutional Amendment Act. And in fact, the 7th Constitutional Amendment Act also extended the jurisdiction of the High Court to any of the union territories. Because the union territories were created, so the High Court shall also have jurisdiction over the union territories. That provision was brought in by way of the 7th Constitutional Amendment Act. So that is another major change by the 7th Constitutional Amendment Act. It allowed for establishment of a common high courts for 2 or more states. The existing high court can also have jurisdiction over another state as well. So this provision was also brought in by the 7th Constitutional Amendment Act. So therefore, in this domain, the 7th Constitutional Amendment Act also becomes very significant. Please come to the next amendment, that is the 24th Constitutional Amendment Act 1971. The 24th Constitutional Amendment Act 1971 was very significant because the 24th Constitutional Amendment Act was brought in more or less to nullify some of the provisions of the judgment which is given by the Supreme Court in the Golaknath case. In the Golaknath case, the Supreme Court said that the fundamental rights are something which cannot be amended. Some fundamental rights are sacrosanct. So in order to nullify that particular part of the judgment, Article 368 was amended by the 24th Constitutional Amendment Act, and they provided unlimited powers to the Parliament to amend the Constitution by amending Article 368. But today this provision does not exist because later it was subsequently done away by the Keshavananda Bharati case, because the Keshavananda Bharati case innovated the doctrine of basic structure, but the Keshavananda Bharati case came only in 1973. Only in 1973, but even before 1973, in 1971, this by 24th Constitutional Amendment Act, this was brought in. And the second amendment that has happened by the same 24th Constitutional Amendment Act is they also inserted Article 13 of the Constitution. If you see what is Article 13 of the Constitution, it says, Article 13, any law which is in violation of fundamental rights can be declared to be void. That is what is Article 13. So now the question is, what is the definition of law under Article 13? Is it only the ordinary law or is it even a constitutional amendment law? And this confusion continued for a long time, and the 24th Constitutional Amendment Act tried to put an end to this. And they categorically said what would be considered to be law under Article 13, only the ordinary law, not a constitutional amendment. That means the result is that if ordinary law violates the fundamental rights, they can be declared to be null and void by the courts by virtue of Article 13. But if a constitutional amendment takes away any of the fundamental rights, they cannot be declared to be null and void. So that is not possible. This provision continues to exist even today, but not this one. And then it is the 24th Constitutional Amendment Act which made it mandatory for the President to give the assent when it comes to a constitutional amendment bill. So whenever a constitutional amendment bill is presented to the President, what is the only option in the hands of the President? It is to give the assent to that particular bill. So this also exists today. Okay. So this is the significance of the 24th Constitutional Amendment Act 1971. Then comes the 25th Constitutional Amendment Act 1971, which inserted one more new article into the Constitution, that is Article 31C. And what is this Article 31C? Article 31C is saying that if any law is made either by the Parliament or by the state legislature, and what is the objective with which this law is made? That law is made to give effect to the provisions of Article 39B and Article 39C of Directive Principles of State Policy. So if the law is made with an objective of either giving effect to Article 39B or 39C, that is distribution of material resources and prevention of concentration of material wealth in the society. If any of these things are the objective of this particular law, then that law cannot be challenged in a court of law even if they are violative of Article 14, 19 and Article 31 at that point of time. But today Article 31 is not part of the Constitution. So therefore, today Article 31C provides protection to Article 39B and C over Article 14 and 19. So this provision continue to exist even today under our Constitution. All right. So the next amendment is the 39th Constitutional Amendment Act, very, very important. 39th Constitutional Amendment Act 1976. Why I would say this is very important? In fact, it was criticized. This amendment was brought in to protect the prime ministership of Mrs. Indira Gandhi at that point of time. So why it was said that it was to protect the prime ministership of Indira Gandhi is because of the fact, in fact, at that point of time, the election of Prime Minister Indira Gandhi was subject to judicial review. It was challenged in a court of law in a case which is called as Raj Narayan case. And in fact, the Allahabad High Court has declared the election of Prime Minister to be unconstitutional. And subsequently, an appeal was pending in the Supreme Court. And when the matter was being heard by the Supreme Court, when the matter was pending in the Supreme Court, when it was sub judice, during the time a constitutional amendment was brought in, and that Constitutional Amendment Act is the 39th Constitutional Amendment Act. And this 39th Constitutional Amendment Act said that any election of Prime Minister, the President, the Vice President and the Speaker in case of Lok Sabha can be challenged only in front of such an authority as may be determined by an Act of Parliament. So therefore, when the matter was pending in the Supreme Court, this amendment was enacted. And then the subsequent hearing, the Council of Prime Minister Indira Gandhi and went to the Supreme Court and said, the Supreme Court has no jurisdiction to look into this particular matter because who can hear these petitions challenging the election of Prime Minister and the other authorities? It shall be challenged only in front of such an authority as may be determined by an Act of Parliament. So therefore, the Supreme Court has no jurisdiction in this particular matter. But however, the Supreme Court has declared this amendment to be unconstitutional. The Supreme Court said that this amendment is violative of the basic structure of the Constitution. It is violative of the basic structure which includes the free and fair elections and the separation of powers under the Constitution of India. So therefore, we are declaring this amendment to be unconstitutional. So this amendment does not exist today in our country, but it was considered to be a very significant amendment. Okay, for the purpose, it was very controversial at that point of time. Please come to the next amendment, that is the 42nd Constitutional Amendment Act, which is also considered to be the mini constitution in our country because it has amended so many provisions in the Constitution. It is considered to be the mini constitution. But most of the provision has been today undone by the subsequent amendments. Some of things continue to be part, but some of the things has been done away with. In fact, the 42nd Constitutional Amendment Act amended the preamble. They inserted 3 words into the Constitution. That is, they inserted the word socialist, secular and the word integrity. Okay, so this is an amendment. They inserted a new part into the Constitution, Part 4A, titled Fundamental Duties. In fact, it was a 42nd Constitutional Amendment Act that made the aid and advice binding upon the President. So that is also true. In fact, the 42nd Constitutional Amendment Act freezed the number of seats to the Lok Sabha and to the legislative assemblies based on 1971 census till the year 2000. So this was done by the 42nd Constitutional Amendment Act. And it is a 42nd Constitutional Amendment Act which said any constitutional amendment is beyond the scope of judicial review. That means they cannot be challenged in a court of law. But anyways, this portion of the 42nd Constitutional Amendment Act was subsequently struck down by the Supreme Court in the Minerva Mills case. So therefore, this does not continue to exist. And then the 42nd Constitutional Amendment Act made the President rule one-time duration of the President rule from 6 months to 1 year. That means we know that whenever the President rule is imposed in a particular state, that the maximum time after the Parliament gives approval, it can be only for a period of 6 months. It can be subsequently extended for another 6 months based on the approval given by the Parliament. But the 6 months time was increased to 1 year by the 42nd Constitutional Amendment Act. And in fact, the 42nd Constitutional Amendment Act shift 5 items from the state list to the concurrent list. So this is today still there in the Constitution, but this no longer exists. It increased the Lok Sabha and the Legislative Assembly tenure from 5 years to 6 years. This was later done away by the 44th Constitutional Amendment Act. Done away with the need for quorum in the legislature. So this has also been done away with. In fact, what constitutes quorum in the legislature is not less than 1/10 of the members of the particular house. But the need for quorum was done away by the 42nd Constitutional Amendment Act, subsequently restored by the 44th Constitutional Amendment Act. All right. So now let us see the 44th Constitutional Amendment Act. So what about the 44th Constitutional Amendment Act? It restored the original term of Lok Sabha and the state legislative assemblies as it brought it back to 5 years. Restored the provisions of quorum in the parliament and state legislature. Empowered the president to send back once the recommendation or the aid and advice which is given by the council of ministers. This is true. Once the president can send it for reconsideration, any advice that is given by the council of ministers, but if the advice is sent back, then he is bound to give the assent. President to impose national emergency only on the written recommendation of the cabinet. Very good. So this was brought in Article 352. In fact, the only article where the word cabinet is mentioned is only Article 352. So today, if the national emergency is to be imposed only on the basis of the recommendation or the written recommendation that is given by the cabinet. Right to property removed from the part 3 and made it a legal right. So the right to property no longer continues to be part of the part 3 of the constitution. In fact, Article 31 was taken out of the part 3 of the constitution. It was placed under Article 300A. So that is one thing. And then Article 19 class 1 subclass F has been completely repealed from the constitution. So these are all the things that you'll have to keep in your mind. And then Article 20 and Article 21 not to be suspended during national emergency. So this was also brought in. So before the 44th Constitutional Amendment Act, under Article 359 of the Constitution, the President can suspend any fundamental right, including Article 20 and Article 21, or the enforcement of the fundamental rights can be suspended. But after the 44th Constitutional Amendment Act, under Article 359, the President can suspend the enforcement of the fundamental rights, but not Article 20 and Article 21. That is not possible. The other rights can be, and their enforcement can be suspended. So all these changes were brought in by the 44th Constitutional Amendment Act. The next significant amendment is the 52nd Constitutional Amendment Act. What is this 52nd Constitutional Amendment Act? If you see the 52nd Constitutional Amendment Act, 52nd Constitutional Amendment Act 1985 in fact has inserted the 10th schedule into the Constitution. The 10th schedule was brought in by the 52nd Constitutional Amendment Act, which is dealing with the anti-defection law. In fact, we have many times discussed this 10th schedule of the Constitution, and there are 4 grounds that is given as to what would constitute the defection under the 10th schedule of the Constitution. And who is the disqualifying authority in all these cases? The disqualifying authority is the Speaker in case of Lok Sabha and the Chairman in case of Rajya Sabha. Similarly, it is the case in the state legislature as well. So these are the things that you'll have to remember with regard to the 52nd Constitutional Amendment Act. Then you have the 61st Constitutional Amendment Act 1989. If you see the 61st Constitutional Amendment Act 1989, in fact, this amendment has reduced the voting age. It has reduced the voting age from what is called as 21 years to 18 years, and thereby bringing more people into the process of election. All right. So this is again a significant development that has happened in the Constitution. And then you have the 69th Constitutional Amendment Act, which has provided the special status to Delhi by inserting a new article into the Constitution, that is Article 239AA. And what were the changes that was brought in by this new article, Article 239AA? All these changes was brought in. In fact, it renamed National Capital Territory Delhi. It renamed Delhi from what is called as Delhi to National Capital Territory of Delhi. It allowed the Union Territory of Delhi to have a legislative assembly, an elected legislative assembly. And apart from that, it also allowed the legislative assembly to make laws on all the items in the state list and the concurrent list, but except item number 1, 2 and 18 in the state list. And the item number 1, 2 and 18 in the state list corresponds to public order, police and land. So except these areas, the Legislative Assembly of Delhi can make laws in the other areas. And it also allowed Delhi to have a council of ministers, including the Chief Minister of Delhi. So these are all some of the special status that was given to Delhi by virtue of the 69th Constitutional Amendment Act in this is not 1969. So there's a small mistake here, I suppose. It should be 1991 if I am not wrong. It should be 1991 or 1990. So that is the year where the 69th Constitutional Amendment Act was brought in. Come to the next thing, that the 73rd and 74th Constitutional Amendment Act. Again, the years are wrong here. In both the cases, it is 1992. The 73rd Constitutional Amendment Act renamed a particular part 9 as what is called as a Panchayats, and the same 73rd Constitutional Amendment Act also inserted a new schedule into the Constitution, that is a Schedule 11, providing for 29 functional items in case of Panchayats. The 74th Amendment Act created a new part, that is Part 9A into the Constitution, and that was titled as Municipalities, and it also provided for what is called as 18 functional items in the 74th Constitutional Amendment Act. So both has happened with regard to this. And then you have the 84th Constitutional Amendment Act 2001. So this 84th Constitutional Amendment Act was a development that has happened over the 42nd. So it is easy, 42nd and then multiply by 2, you get 84th, or 42 plus 42, it is 84. Why? In one case, both amendments are dealing with the same matter. While the 42nd Constitutional Amendment Act fixed the number of seats to the Lok Sabha and the legislative assemblies based on 1971 census, but that was till the year 2000. The 84th Constitutional Amendment Act in the year 2001, they made amendment to the same provision and they extended this 1971 census till the year 2026, or till the first census that is published after the year 2026. So in both the cases, they freezed the number of seats based on 1971 census. And then you have 86th Constitutional Amendment Act. This Constitutional Amendment Act is significant in the sense it amended all the three parts in the Constitution. It amended Part 3 of the Constitution, Part 4 of the Constitution, and Part 4 of the Constitution. Part 3 was amended and inserted Article 21A, right to education as a fundamental right for 6 to 14 years. Before this, a similar provision was there in Part 4 of the Constitution, that is in DPSP. So therefore, instead of 6 to 14 years, a change was brought in and that has been made to 0 to 6 years. And then a fundamental duty was also inserted. In fact, the last fundamental duty, it made the guardian or the parent to provide education to the child as a fundamental duty. That change was also brought in by the 86th Constitutional Amendment Act. So all these changes were brought in by the 86th Constitutional Amendment Act. Please come to the next amendment, that is the 91st Constitutional Amendment Act. The 91st Constitutional Amendment Act reduced the size of Council of Ministers both in case of Union as well as in case of the states. In the Union government, the size of Council of Ministers was restricted to 15% of the total strength of Lok Sabha. Whatever may be the total membership of Lok Sabha, in that the number of ministers can be only 15%. The same 15% is also in case of the states, and it depends upon the size of the legislative assembly, state legislative assembly of that particular state. So this is what you will have to understand. So be it legislative assembly or be it Lok Sabha, 15% of them can be the maximum size of the Council of Ministers, but there is an exception to this. If any state, especially in case of state, where this 15% will be less than 12. So in that case, there can be a minimum of 12 ministers. So only when this 15% will be less than 12, then there can be a minimum of 12 ministers. And the 91st Constitutional Amendment Act also says, anybody who is disqualified on the grounds of defection, then he cannot be appointed as a minister. Because there is a provision in the Constitution, someone who is not a member of Parliament can also be appointed as a minister for 6 months. But someone who is disqualified on the grounds of defection is not eligible to be appointed as a minister. He can be appointed as a minister only when he gets re-elected to the House. Okay, so that's what the understanding you should have. And this amendment is part of the 10th schedule of the Constitution. The defection law is dealt under the 10th schedule. So all these things are brought in by the 91st Constitutional Amendment Act. 99th Constitutional Amendment Act deals with the system of collegium system. In fact, the collegium system no longer exists. This 99th Constitutional Amendment Act was initially immediately struck down by the Supreme Court in 2015. Because in the opinion of the Supreme Court, this 99th Constitutional Amendment Act, which brought in the National Judicial Appointments Commission, replacing the collegium system in our country, in the opinion of the Supreme Court, this National Judicial Appointment Commission is violative of the basic structure of the Constitution, that is the independence of judiciary. So therefore, the entire amendment does not exist in the Constitution today. 100th Constitutional Amendment Act. This is related to exchange of enclaves between India and Bangladesh. And because you are exchanging enclaves between India and Bangladesh, an enclave is a small portion of a land of one country which is completely located inside another country. So India and Bangladesh started exchanging these enclaves, because when India and Bangladesh exchange these enclaves, which also means that they have to transfer some of the land to Bangladesh. That means India has to cede a territory to a foreign country, which can happen only by a way of a constitutional amendment under Article 368, which we already seen in the Birubar Union case. So therefore, to exchange these enclaves, a constitutional amendment was carried out, and that is the 100th Constitutional Amendment Act. Please come to the next thing, 101st Constitutional Amendment Act, which paved way for what is called as a goods and services tax in our country. It is a very big indirect tax reform, and that indirect tax reform was allowed by the 101st Constitutional Amendment Act. Accordingly, certain tax reforms were brought in into the constitution, and to deal with the indirect tax reforms, an apex body was established, which is the Goods and Services Tax Council. And the Goods and Services Tax Council is established by virtue of Article 279A, and that was also brought in by the 101st Constitutional Amendment Act. Then 102nd Constitutional Amendment Act, which has inserted a new article, that is Article 338B, by which today the National Commission for Backward Classes was given a constitutional status, in line with the National Commission for Scheduled Caste and the National Commission for the Scheduled Tribes. Article 338 provides a constitutional status to the National Commission for Scheduled Caste, and Article 338A provides a constitutional status to National Commission for Scheduled Tribes. Article 338B provides the president to, Article 338B provides this constitutional status to National Commission for Backward Classes. So as per this, the president is empowered to determine the backward classes, which shall be further amended by the parliament. Alright, so this is the provision of the 102nd Constitutional Amendment Act. 103rd Constitutional Amendment Act provided for what is called as EWS reservation, providing 10% of seats to economically weaker sections, both in public employment as well as in the educational institutions. To provide 10% reservation to the economically weaker sections, there was an amendment that has happened to Article 15 Clause 6. And to provide 10% reservation to the economically weaker sections in public employment, Article 16 Clause 6 was amended. So this is basically what you'll have to understand. Economically weaker sections means those who are from general community but who are economically weaker. So that is basically what is an economically weaker sections. Please come to the next article, that is 104th Constitutional Amendment Act. The 104th Constitutional Amendment Act extended the reservation that was given to the scheduled caste, scheduled tribe in the Legislative Assembly in the Lok Sabha elections for another 10 years. You might know that today there is reservation to the scheduled caste and scheduled tribes when it comes to election to the Lok Sabha and the Legislative Assemblies. That was given in the original constitution itself. But in the original constitution, this reservation was to be given only for the first 10 years. Not more than that, only for the first 10 years. But however, the constitution may be amended and can be extended subsequently. In this manner, every 10 years, the constitution was amended and it was extended subsequently. But in 2019, when this particular amendment was brought in, while the extension was given to the scheduled caste and scheduled tribe, but there was no extension that was given to the Anglo-Indian nomination, because in the original constitution, there was a provision for an Anglo-Indian nomination also. That 2 persons from the Anglo-Indian community can be nominated in the Lok Sabha by the president, 1 person from the Anglo-Indian community can be nominated by the governor in the Legislative Assembly. But this is also to be subsequently extended. This was also to be for the first 10 years, but can be extended by another 10 years by an amendment to the constitution. So by every 10 years it was amended and it was extended. Till 2020 it was extended, but to extend it from 2020 to 2030, you will have to make an amendment, and that amendment was 104th Constitutional Amendment Act in 2019. So this amendment has extended the provision of reservation for the scheduled caste and scheduled tribe, but the provision for nomination for the Anglo-Indian has been done away with. So today the Anglo-Indian community do not have any nomination provision in the Lok Sabha or in the state legislature. That is discontinued. 105th Constitutional Amendment Act in the year 2021. This is related to giving constitutional status to the National Commission for Backward Classes. I said when the National Commission for Backward Classes was given the constitutional status, I also said that the president was empowered to determine the backward list, subject to the amending powers of the parliament. So a question was arised that whether this president who is empowered to make the backward list, is it only for the center or also for the states? And there was a confusion as to whether the president will have the power to make the backward list list for both the center as well as for the states, or is it only for the center? To avoid this particular confusion, a particular amendment was brought in, that is the 105 Constitutional Amendment Act or the 105th Constitutional Amendment Act, which categorically says that the president will prepare the list only in case of center, and the states can prepare their own list of backward class for the state recruitment, the state government recruitment, also for the state educational institutions. So that power was restored to the states by virtue of the 105th Constitutional Amendment Act. All right. And now the last amendment is the 106th Constitutional Amendment Act 2023, which in fact a historic step in our country, providing 33% reservation for women in both Lok Sabha as well as in the legislative assemblies. Initially, this 33% reservation was given only in the panchayats and the municipalities, but now it has been also extended. But however, the law is yet to be implemented. So as per the constitution, if you see, this 33% reservation is only for the first 15 years, but then subsequently it can be extended again by way of an amendment. And when this law will get implemented, or when this 33% reservation will be implemented, it will be implemented after the first census subsequent to this amendment, whenever the first census will happen. And based on the first census, the delimitation exercise has to happen. And then the law can get implemented. That is, a 33% reservation can get implemented. That means, unless and until the census is happening after 2023 and the delimitation exercise is completed after this amendment came into force, this amendment cannot be implemented. So this is basically what you'll have to understand. I hope till this point of time it is very clear. So now we are coming to the end of this particular lecture. Which of the following amendment provided for EWS reservation? So which of the amendment provided for EWS reservation? It is the 103rd Constitutional Amendment Act. So it is for you to answer, but in this case I have answered it myself. So the answer is option A in this particular case. So with that, we are winding up this particular lecture, lecture number 122 on important constitutional amendments. In the next lecture, I will deal with important articles in the Constitution. Students do ask me, do we have to remember all the articles? You definitely don't have to remember all the articles. But yes, few articles will automatically get into your mind. Over a period of time, you keep reading, revising, it will get into your mind. So next lecture, I'll deal with the important articles. So now we are ending this particular lecture. So thank you very much for listening to this particular lecture. If you like this video, you can share it with your friends, and I'm sure that it will be really beneficial to them. And if you have any queries, concerns related to the preparation, you can reach out to me through my Instagram account or through my Telegram channel. And you can consider me as your friend, mentor, or a guide who can help you in clearing this particular examination. Thank you very much and all the very best.